rise. The Court of Appeals Division 1 is now in session.
Thank you. Please be seated. Good morning. This is the time set for oral argument in our cause number CV140658, Stasinski versus NRT Arizona LLC et al. Counsel, we are recording today's proceedings, so when you step to the podium, please identify yourself and the client that you represent. Each side will have 20 minutes for argument, and Mr. Jacobson, as the appellant, you're responsible for watching the clock and reserving any time for rebuttal that you might desire. We have read the briefs and we've conferenced the case prior to argument. So with those preliminaries, Mr. Jacobson, you may proceed.
Good morning. I represent the plaintiffs, appellants Stanley and Patricia Stasinski. May it please the court, my job in this appeal really is to prove one key issue, and that is across the three relevant motions for summary judgment that are at issue in this appeal, is there a single, just one or more, genuine issue of material fact that would warrant at least a reversal in part? And I submit that the record below on the briefs, the motions, demonstrate that there's several genuine issues of material fact that would warrant at least a reversal in part. I know that there's been some decisions and a lot of briefing, and there's a comprehensive record concerning the first motion for summary judgment on the easement issue. So I would like to start on motion.
Well, haven't there been two decisions issued, one involving the Lindhalls and the other one involving Coughlin? So those issues are resolved, and the only one that is left is the one against Coldwell Banker for damages.
Yes, and this appeal is unique. There's been no rulings in the other court cases as to Caldwell Banker class.
Okay.
I would like to start off addressing the second motion for summary judgment, and that's the Satch's purchase offer. The heart and soul of that is this. Connie Sue class of Caldwell Banker represented the Stasinskis when they were trying to sell the properties before the foreclosure. Connie Sue class then went, and after Stan had informed her that he was going to make try to get a deal with the Satches and would like to negotiate a transaction, she went and signed the Satches up as their client too. So Caldwell Banker and Connie Sue class now represent a buyer and a seller on a real estate transaction on the eve of a foreclosure. And so Stan Stasinski gets a written purchase offer. Ms. Class delivers it to Stan and advises him to reject it. And he does a counteroffer, and the Satches don't accept. Our expert, Ed Ricketts, is very unhappy and has written a scathing declaration affidavit. He's our standard of care expert. I would like to bring your attention to our statement of facts. It's record 84 on the second motion for summary judgment. It's also in our appendix number 7. Exhibit 3 of that is Mr. Ricketts' affidavit. It's, 2 affidavits. He's very critical of Caldwell Banker and has come up with a laundry list of reasons why Caldwell Banker violated the professional standard of care for brokers and real estate agents. As to the Satches transaction, he spent some time going over the duties of Ms. Class in getting consent to represent both a buyer and a seller in a real estate transaction. And by the way, my client never knew that Ms. Class was representing the Satches until he learned it from me a couple years ago. And exhibit, Ed Ricketts has done 2 affidavits that are a part of record 84. It's our statement of facts. The first affidavit in there, it relates to the original transaction and the listing claim. Remember, a big part of this case has to do with her relisting the property within months of him buying it for about 4 times as much as he bought it for without doing any sort of analysis. The second affidavit, which is exhibit 4 of that statement of facts, he really focuses in on the SATS transaction. And I would like to highlight a few things. And again, this is to show that there is a genuine issue of material fact that warrants at least a reversal in part as to the SATS transaction. He goes through a chronology of dates on page 4 of that affidavit. Paragraph K says, on the evening of March 16th and the morning of March 17th, respectively, the Satches and Stasinski signed a consent to limited representation. It goes on. It's called a dual agency. Under this dual agency, class recommended that Stasinski's make a counteroffer, apparently prepared ahead of time by class, that required the Satches to pay $62,000 in closing costs and includes class's dual agency commission. It also required some earnest money to be non-refundable. 4 days before the foreclosure sale. So our expert has, in this affidavit, talked about the violations of the standard of care and also possible ethical violations as it relates to the SATS transaction and the listing claim by failing to conduct a comparative market analysis, failing to obtain the informed consent of the Stasinskis before acting as a dual agent, orchestrated a dual agency representation at a time when the Stasinskis desperately needed her advice and advocacy, 4 days before a foreclosure, failed to advise against the counteroffer that killed the transaction and resulted in the continuance of the trustee sale on the Mule Tree Ranch. Paragraph 11 on in page 7, breaches of the broker standard of care in this case resulted in damages to the Stasinskis, which have been calculated by a damages expert, which is the next affidavit in that statement of facts. Leroy Gaitner is our CPA, and he has done a comprehensive report as to the damages on the listing claim and the damages as to the lost profits on the SATS transaction. Motion for summary judgment number 2 should have been denied.
Well, let me back up. When so that I understand, at least the motion for summary judgment that gave rise to what I thought was this appeal was a little different. What was the date of Judge Trebish's ruling in that matter?
Okay, there's been 3 key rulings. That's Appendix 10 of our, it's Part 2 of 3 of our Appendix 10. The ruling on that one was February 18th, 2014, and it's Record 135. She got the chronology of dates totally wrong, and I'll be honest with you, I do not understand her ruling. She does not really even acknowledge Ed Ricketts' affidavits. I'd like to move on to motion for summary judgment number 3. This is focuses on the listing claim. My clients purchased property in 2005 for $1.2 million. Within 6 or 7 months, Caldwell Banker listed it for $5 million without doing an appraisal, a comparative market analysis, or anything else. The years went by, there were some adjustments to the price. Even as appraisals were done by the bank, $3.5 million, they were still listing it way above that. And our expert has said that violated the standard of care by failing to have the Stasinskis authorize some sort of comparative market analysis, appraisal, or even an informal investigation of some sort. Something other than just pulling a number out of the air. That's basically what happened here. Leroy Gaitner disclosed his written reports in this case. I timely disclosed them, and he addresses the fact that the listing claim, which I would like to, our motion for summary judgment number 3, which is in the record at 169 and 171, that's our response statement of facts. It's our appendix tab 12. Under appendix tab 12, we have some key expert reports that create genuine issues of material fact that I think should be clear in the record. First of all, during the deposition of Leroy Gaitner, opposing counsel asked some questions, and most of the deposition was focused on this easement issue. And even though his written report had a very large line item for the listing claim as a part of the overall damages, opposing counsel thought there had been an admission that he was somehow modifying his opinions and not including a listing claim. I clarified that with him in supplemental disclosure statements, supplemental affidavits with Leroy Gaitner, and they filed a motion for summary judgment saying, well, because he admitted during his deposition he wasn't doing a report on a listing claim, even though it was in his report, we win. And it was granted. We submitted an affidavit from Mr. Gaitner that said that the opposing counsel misunderstood his testimony, that he was including a very large component in the listing claim, and I cited a case that indicates after a deposition, if there's a purported admission and that expert or deponent submits an affidavit that's in any way contradictory to the deposition, that creates impeachment evidence for a trial. It doesn't warrant a motion for summary judgment. It's something you would use at trial to impeach an expert on the stand. And we've cited the case in there. So we do have the biggest claim we have in this case is the listing claim.
And the last affidavit in response to the motion for summary judgment did in fact, I read it but I don't remember it right now, clarified why this additional affidavit had to be submitted in light of the earlier deposition, supplemental disclosure and affidavits.
There's two arguments going on in that third MSJ. One relates to Leroy Gaitner and the fact that
but it's as to his affidavit that I'm speaking of, at least.
Well, yeah, they filed an MSJ based on his deposition. If you would, Your Honor, I will show you in the record, again, under the statement of facts.
Okay.
If you, actually, in the statement of facts itself, which is, again, record 169, we had filed that Gaitner affidavit earlier in the record, so we don't attach it there. But on page 3 of our separate statement of facts, paragraph 1, which is on page 4 now, Gaitner affidavit of 22414, and the following paragraphs talk about how he calculated the listing claim, how the opposing side misunderstood his testimony, and then we included a supplemental disclosure statement showing that when I realized they were making that claim before the deadline for the absolute deadline to do disclosures, I did a supplemental disclosure clarifying the same thing that was already in his report. Again, the case law says that subsequent affidavits of controvert prior depositions for an expert is impeachment evidence to be used at trial. It doesn't warrant a summary judgment. The other issue that came up in this third motion was Ricketts. Somewhere along the line, opposing side said, well, because Ricketts' earlier affidavit said that it violated the standard of care not to do a comparative market analysis, we should get a motion for summary judgment because you guys never did a comparative market analysis for damages. And Ricketts said, well, that's not really what I was saying. I was saying that Caldwell Banker violated the standard of care by doing nothing. No comparative market analysis, no appraisal, no nothing. And so he clarified that in his report. And he said that you don't have to do a comparative market analysis. Our damages is based on an actual appraisal that was done, and the difference between that and the purchase price, our experts have said it would have sold. But because Caldwell Banker had it listed so high, it didn't sell. So we used an appraisal, which is better than a comparative market analysis, to do our damage calculation. So I'd like to, if you had any questions, I'd be happy to address those. Otherwise, I was going to reserve the remaining 6 minutes for.
Can you tell me which case you were referring to when you said that the Gaitner supplement was proper and didn't fall under the sham affidavit category?
I believe that is in, our response to Caldwell Banker's motion for summary judgment was filed on April 11th, 2014. It's record 168, and it's tab 11 of our appendix.
But you said there was a case that stands for the proposition that was fodder for impeachment, but that it did not warrant summary judgment. So I was looking for the case that you were relying on.
You can tell us in your reply.
Yeah, if you want to look at it.
I will get the exact page number.
Okay.
All right.
Thank you. And Mr. Watson.
Good morning. Dax Watson on behalf of NRT Arizona, Jim and Connie Sue class. I have to admit that I'm a little confused by Mr. Jacobson's opening position relating to the Sachs transaction. I don't know how that's even before you. It's not part of this appeal. If I was looking, I looked at his brief while he was talking. The only mention of the Sachs transaction is at page 12 of his opening brief, and it relates to the Coughlin defendant's motion relating to that transaction. So he came before you and spent the first 5 to 8 minutes of his argument suggesting that you're here to decide whether or not my clients did something wrong in that transaction, and that's not before you from anything that I've seen. So unless you have questions on that, I'd like to move to the listing claim. No questions. All right, I think that we have to be careful here and procedurally look at what was before the judge, because Mr. Jacobson wants to focus on affidavits, so forth, the sham issue, which I will get to. But we got to start with what first and foremost was before the trial court. There was a claim. The claim that was alleged was that there was an improper listing. The actual allegation in the complaint said that Connie Sue Class and Caldwell Banker breached the standard of care because they failed to perform or undertake a comparative market analysis, a CMA. That was the claim. We filed a motion for summary judgment after the close of discovery, after Mr. Ricketts had given his opinion, after Mr. Gaynter had been deposed, because the one thing that was absolutely missing was the backup to that claim. If you're going to allege that Caldwell Banker was required to do a comparative market analysis for this vast parcel of land in order to create the appropriate listing price, then in order to satisfy your burden of proof so that the fact finder can actually have something to consider, you have to provide a historical comparative market analysis that will tell the jury, will tell the judge, they didn't provide a CMA. If they would have done one, here's what it would have said. That was the motion for summary judgment. And if you read the trial court's decision on this and you read her ultimate ruling, she focused on that. She absolutely saw that the issue was there was no CMA for anybody to look at. There was no evidence for them to support the claim that was filed. You have to have some historical CMA to say why the failure to get a CMA meant your listing was too high. All right, so let's not get sidetracked with this later creative idea that we're going to create a new claim. That was the claim. That's what the judge ruled on. So then what happens? We file the motion for summary judgment. What do they not do? They don't ask to amend their complaint. They don't say, all right, Judge, we need to amend our complaint. And why that's important, and Judge Portley, I see you looking at me, she's like, why is that important? At least I thought you were thinking that. I'm sorry.
Actually, I'm Judge Orozco. I think.
Oh, you guys, that's why I thought that was true, and because I've been before you before, but I thought, well, maybe it has been a while. your nameplates are switched.
We like to do that. Counsel.
Okay, all right. I was like,
Just trying to
I
mess
thought
with
maybe
you.
I'm crazy.
We're just messing with you.
Okay. This is hard enough. You don't need to change your nameplates on me. But let me tell you why that's important. Because remember, the claim was a CMA claim. After we file our motion for summary judgment, after discovery's done, after Mr. Gaynter unequivocally in his deposition said, look, I've done no damage calculation at all on the listing claim because I would need information from Mr. Ricketts to help me do that, and he's never provided me that. After all that's done, they come in and they say, oh, wait a second. What we meant by our CMA claim was that she should have done something to value the property. And what she should have done is rely on some appraisal that was done in 2007. It's called the Huck appraisal. All of a sudden that comes flying out of nowhere. And that's what we really meant. Okay? They're responding to a motion for summary judgment trying to correct errors in their claim after discovery was over. Never amended their claim. Because remember, the only thing you're here to decide is whether or not the judge properly ruled on a motion for summary judgment on the listing claim. And the listing claim as pled said unequivocally the failure was not doing CMA. So I guess one way to correct this, if you want to historically go back and fix the errors in how things were done, was to file a motion for leave to amend and say, well, it wasn't just the CMA. They had to do an analysis of the Huck appraisal, or they had to do something else. They never did that. Now, getting into the sham affidavit, I mean, I like Mr. Jacobson. I've known him over the years. I respect him. But this clearly was an effort to change testimony. It wasn't even a question. We have quoted word for word in our brief what Mr. Gaynor said about damages and what analysis he said he did. And this isn't correcting this. This isn't, oh, it was a mistake. He unequivocally was asked, did you perform a damages analysis relating to the listing claim? He said no. Then after we filed the motion for summary judgment, we have the new Ricketts declaration that comes in and says, oh, you can use the appraisal. After the deposition, after discovery, here comes the new Gaynor deposition, or new testimony. Oh, I was mistaken. I actually did calculate this. The reality is they didn't have the evidence to support the CMA claim. They never amended the complaint to allege a new one. The only thing before you is a review of a very good trial judge who looked at this and decided a motion for summary judgment based off of the evidence that had been presented and the lack of evidence and the actual inability for them to take this case to trial. Because again, big picture, if they're sitting in front of the jury and they say to Mr. Ricketts, how did they violate the standard of care? They didn't perform a CMA. What's the next question? If they performed a CMA, what would have it said and what would have the proper listing been? His answer would have been, I didn't perform a CMA, so I do not know. How do they establish their case? How do they prove their case? The judge made the right ruling. So unless, I know I've got a lot of time left, but I think it's pretty simple and pretty straightforward. So unless you have any questions, I will sit down.
No,
Thank you.
And rebuttal, Mr. Jacobson?
Okay, I will start with the sham affidavit arguments. And plaintiffs did a reply. It was record 185, and it's tab 13 of our appendix. In that reply, there's an argument section that begins on page 5, because they had raised the sham affidavit cases, the Wright and McLean cases. I went over the exceptions listed in those cases and showed why we qualified for the exceptions. I showed the timeline. Again, there was no MSJ pending when he did the affidavit.
But let me go back to something you said in your opening comments, which was that you could supplement Mr. Gaynor's opinions, but that's not really so, because not only had discovery closed, but the deadline for disclosing expert opinions had closed. So this wasn't a situation where prior to the close of discovery, you're supplementing an expert's opinions. What authority did you have to supplement his opinions?
I addressed that in my timeline. On pages 6 and 7, we disclosed his written opinion on the value of the listing claim on July 6, 2012, in a disclosure statement. He was deposed almost 2 years later, February 13, 2014. We did a supplemental disclosure statement 8 days later on our own, on the deadline to do supplemental disclosures, February 21st, 2014. We clarified what our listing claim was, just going back to his earlier written report. The trial court vacated the trial a couple days later, and I sent an email on February 24th allowing them to, opposing counsel, to redepose Mr. Gaynor on February 24th. I have all this in there. We quote from Mr. Gaynor's affidavit. He says here on page 6, I did not change or alter my previous opinions from my 2 expert reports during my deposition concerning the damages arising out of the listing claim. My opinion has been, and still is today, that the listing claim damages are $2,373,000. I believe that the attorneys for Caldwell Banker have misunderstood my deposition testimony, mischaracterized it, and misquoted it. Then, the trial was canceled. Then the other side wanted to disclose a brand new expert, and the trial court granted it after these dates. At the
You
bottom,
also said you were going to find a case.
yeah,
that-
bottom
of impeachment.
of page 7 of that is the Thompson case. which says conflicts between depositions and subsequent affidavits present questions of witness credibility. But credibility, weighing of evidence, and drawing of inferences from facts and witnesses are jury functions, not those of a judge.
What's the cite
What's
of
the
that?
citation to that case?
It's Thompson versus Better Built, 171 Arizona 550. It's a 1992 case. I also have a string cite to Anderson versus Libby DeLavi, Orm School, and I'm also citing Federal Practice and Procedure.
How do you square that though with the well-known line of cases well established that you can't avoid summary judgment through an affidavit that conflicts with sworn deposition testimony? I mean, I need to read the Thompson case.
That's when it's
obviously.
submitted.
That would seem to be an outlier.
Those cases don't even apply to the situation. Those have to do with when you submit an affidavit when there's been an MSJ filed against you. We did all of our affidavits and supplemental disclosures long before their motion for summary judgment. See, on page 6, I go over, I'm sorry, page 5, I go over why the case doesn't apply. For example, Wright and McLean did not address the issue presented here, where an independent expert witness, as opposed to a party, gives a deposition and then promptly discloses an affidavit just 11 days thereafter, explaining his deposition, expert opinions, and within that affidavit explains how opposing counsel has misunderstood his deposition. Number 2, executes an affidavit with no motion for summary judgment pending. Number 3, discloses the affidavit 99 days before the trial date. Number 4, the expert is made available for a continued deposition 2.5 months before the trial date. And number 5, the expert had previously disclosed in his written expert reports years earlier the opinions in dispute.
What did any of your experts do a CMA, a comparative market analysis?
No,
Okay.
something better was done, an appraisal.
Well,
And
but how do you square it with Mr. Watson's argument that your complaint said that it was an improper listing because the defendants did not file a CMA? And so you asked the question, they didn't do a CMA. What would the CMA have said if they had filed it? I mean, how do you respond to Mr. Watson's argument?
Your Honor, you know an appraisal is a much more thorough investigation of value.
But the question is, your own allegation was the breach of the duty of standard of care was no CMA, so that's your own allegation.
Our expert is clarifying in, and I'd like to draw your attention to the exhibits to plaintiff's surreply controverting statement of facts of May 27th.
But we're talking about a pleading.
Yeah,
Your theory of the cause of action. I mean, it's surreplies and all. How can you not amend to say, oh, well, we actually mean the breach of the duty of care is something else?
Yeah, our expert is clarifying that. Ed Ricketts has done a supplemental declaration in Exhibit 1, and here he says,
I get that, but pleadings govern the case as it progresses. Mr. Ricketts doesn't file the complaint, doesn't tell the court what the causes of action are. I mean, I think Judge Orozco's honing in on that point that Mr. Watson made, which does seem to be a problem, that your own allegation of the breach isn't consistent with what you're later trying to show.
We never limited our experts, our allegations, and our disclosures were never limited to the only way to comply with standard of care is to do a CMA. I would like to read Ed Ricketts's.
But that's it. Doesn't matter what your experts say. What concerns me is the fact that you say that the defendants were negligent because they didn't do a CMA.
They didn't do an investigation, appraisal, or a CMA. It's a list of, there's a wide variety of ways they could have complied with the standard of care, which Ed Ricketts says.
Okay, you've got 30 seconds to sum up,
Okay.
so make your best point and then we'll be done.
Paragraph 5 of his affidavit, Class and Caldwell Banker could have met the broker standard of care by conducting a CMA or by commissioning an appraisal, although an appraisal is generally conceded to be the better practice, which is what happened here.
Thank you. That'll need to be the last word.
Okay.
Thank you both for your arguments. We will take this matter under advisement and issue a ruling in due course. At this time, we will stand in recess until our next argument. Thank you.